Hi, my name is Noelle George, and I'm going to talk to you about criminal voting laws. So, for some background, voting is considered to be one of the most important U.S. citizen civic duties because it is the main link between the people and the government that serves them. So, according to colonial law, criminals were excluded from voting along with other parties, such as women and people of color. So, criminal voting rights first became a more pressing issue after the Civil War during the Reconstruction period, when amendments were passed that gave all men the right to vote. The Constitution reserves the power of voting disenfranchisement to the states. However, the wording does suggest that disenfranchisement should only be reserved for serious crimes. So there's no specific policy that's outlined in the Constitution because that power is reserved for the states. Currently, about 2% of the adult population is denied the right to vote due to their criminal past, with a disproportionate 13% of adult African Americans being denied the right to vote. And this kind of reflects the historical nature of creating an inequitable system that excludes minorities from voting. So it's kind of today's version of Jim Crow laws, as it disproportionately affects people of color and other minorities from voting. So a landmark case is Richardson versus Ramirez, which happened in 1974. This case was brought against the state of California by 3 ex-felons who were representing themselves and other ex-felons who were disenfranchised. And this happened in 3 different California counties, and they were challenging this on the grounds that it violated the Equal Protection Clause, which was in the 14th Amendment. The California Supreme Court ruled that the disenfranchisement of convicted felons did not violate the Equal Protection Clause, and this decision was upheld by the U.S. Supreme Court. And it allowed the states to continue to choose if they wanted to disenfranchise felons or not. So the current criminal voting policy is kind of all over. There's some states that have a very liberal stance on it, such as Maine and Vermont, and then there's a whole scale and range that ranges all the way down to states that have a very severe penalty, which includes disenfranchisement during their prison sentence, parole, probation, and after. And here's another visual that just kind of shows us some more geographical trends, such as the Northwest, which has quite liberal policies and is generally more in favor of maintaining the right to vote, whereas the South is usually a little more strict with their policies. And some articles have stated that this is very racially motivated and a very taboo topic because it such disproportionately affects people of color and other minorities, and that it's just another way for the government to limit these people's access to democracy, while there's other reports that kind of follow the more general American population and their opinions on it, which state that most people think that our voting rights should be taken away if the person is in prison, but after that, once their sentence is complete, that they should be able to vote again. And there's just a very wide stance on this topic. Some people think it's very polarized and that it has a very strict kind of source, while others just kind of think if someone made an offense against society, their kind of link to society should be taken away through disenfranchisement. So how does this have to do with the NASW ethical standards? So there's 2 standards that's kind of touch on this topic. So standard 602 regards with public participation, and that's kind of the idea that disenfranchised populations should go to the polls and vote. So that's saying kind of that these people who are minorities should be encouraged to vote and should have equal access to voting. And then 604 is kind of social and political action, and that is encouraging social workers to take action to ensure that nobody is discriminated against. So in this case, a majority of states or I would say kind of half of the states currently align with this and say once they're out of jail, they should be able to go vote. And then kind of half of them have a more strict policy. So it really depends state to state. But I think in general, having a more liberal mind with regarding the NASW would be more along the lines that everyone, regardless of their conviction of their past, should be able to vote. That's kind of what it's saying here. So my question for you is, do you think disenfranchisement is a violation of our rights? Like I said, voting is a very basic right that many Americans believe is integral to our democracy and that everyone should have access to that. And the other question I have is, are there crimes serious enough that warrant disenfranchisement permanently as a punishment? So I would love to hear your responses. Thank you for watching. Bye.